Well, hello and good evening, everyone, and welcome to the Provincial Association of Resort Communities of Saskatchewan's Lake Water Wednesdays. We're very happy tonight to welcome Dr. Pamela Martin, who will be speaking about the water rights as pathways to sustainable development. Please join us next week as we have Dr. Peter Levitt talking about water quality in Saskatchewan lakes and what affects them. This webinar will be recorded, and if you have any questions, please do type them in the question box, and we will go through a Q&A at the end of the session. Before we begin with Pam, though, I would like to introduce to you Lynn Sass. Lynn is the Coordinator of Member Services with Parks, and is the one that is behind sort of organizing Lake Water Wednesdays. This was sort of Lynn's brainchild. So with further ado, here's Lynn.
Thank you, Chuck. Hello, folks out there. Chuck told me to be brief, and I have trouble with that. So I'll be, instead of being brief, I'll be fast. My job is to introduce Pamela, and I'm going to get to that in just a moment. But first, Pamela, I'm going to introduce you to Saskatchewan lakes and Saskatchewan people. So you're the listener, and the rest of the folks can listen in. On my right, I have a great big huge map of Saskatchewan with all the lakes, but rather than upset the recording right now, I'll just tell you about it. It shows the bottom 2/3 of Saskatchewan because the top third is all forests, kabillion lakes, lots of forests, but not many people, and primarily very healthy lakes. But the bottom 2/3, I want to tell you just a little bit about. The Provincial Association of Resort Communities Parks divides the bottom area, which is mostly the agricultural part of Saskatchewan and all the towns and villages and cities, etc. We divide it into 4 areas for the purpose of governance and so on. And the northeast and the northwest are right across, slack dab across the middle of the province. And there are about 20 lakes in that northern area. The biggest lake is, with the most people in it, is Candle Lake. One of the lakes that has a lot of communities and has the newest community at all on it is Turtle Lake, which has the brand new resort village of Turtle View. Anyway, there's 20 lakes up there in the north. And the reason that those lakes are ours to enjoy and ours to manage and ours to worry about is because in 1906, a treaty was signed. Treaty 10 was signed between the Canadian government and the representative of those First Nations. And they gave those lands, and we call them the Treaty 10 lands, and those waters to us in trust that we would manage them for future generations. Now, if you move down to the bottom of the map, there's a left side and a right side. On the left side, there's an area that used to have very little in the way of lakes, a couple of little tiny lakes. But there was a great big long river going through it called the South Saskatchewan River, bringing water out of Alberta from the mountains. And the previous generation, my father's generation, decided to build a dam and create a lake 225 kilometers long, and another adjunct lake called Blackstrap Lake. And now there's a great deal of development around these lakes and a great deal of responsibility for the cottage communities and municipalities that around these lakes, because those waters now feed all across other lakes and right across the province. And then when you get into the bottom right-hand corner, there's 6 little sweetheart lakes all joined together called the Capel chain. And those poor dear lakes are under a lot of challenge and in need of a lot of help because of interference with things that are really interfering with their water quality. And then there's a big long Last Mountain Long Lake. So we have a lot of lakes down in the bottom, 20 across the top middle, and I would say a total of about 16 across the bottom, all of them having about 110 communities in total, and we are charged with that responsibility. It's a big one, Pamela. And so we're really anxious to hear from you, because it's a new idea, Pamela, that the lakes themselves have rights. But well, they should. When you think of that great big long 225-kilometer lake that was established there, it was established in an area where Treaty 6 was signed. And every time our forefathers signed a treaty with First Nations, they signed an agreement to look after the land and the water. The same thing with those Capel lakes. They fall in Treaty 4 lands. And so I give to you, Pamela, a total of a kabillion little lakes. All of them have things they probably need help with. And all of them came to us from our First Nations forebears to our from the time of the mid-1870s right up till 1907. Now, ladies and gentlemen, I want to introduce Pamela. She is a teacher at the Coastal Carolina University in the Department of Politics. She does a lot of research and writing about global environmental issues, and she is executive director of the United Nations Regional Center of Expertise on Sustainable Development, which is there in her part of the world. And she's on a campaign to have us recognize that lakes have rights, and it's our job to support them. Thank you for coming, Pamela.
Well, thank you so much. I really appreciate that, Lynn. What a beautiful introduction, and so absolutely apropos of much of the work that I've been doing with my co-author, Craig Kaufman. We have an upcoming book coming out in August, and it's entitled Rights of Nature, Pathways and Strategies Towards Sustainable Development, and I'll explain why. I want to thank the invitation from you and from all of the people associated with this conference, my friends in Saskatchewan, Roger Petrie and his wife Jill, and all of the people at RCE Saskatchewan for this lovely invitation. My email is listed here should anyone want to get in touch with me further. And I'm going to share my screen right now. Can everyone see that?
I have the slide.
Okay, good, excellent. So I just wanted to show you a little bit of where RCE Georgetown is. So that is our county seat. So make a connection from where you are and the beautiful lake region where you are to the 5 rivers that flow out into the 3rd largest water basin on the East Coast, where I am on the Winya Bay, and that is our clock tower. And so much like all of you, we have as Lynn kindly pointed out, a regional center of expertise on education for sustainable development, and we partner with the North Inlet Winya Bay National Estuarine Research Reserve. So I work with Coastal Carolina University. I work on sustainable development and policy in terms of global environmental policy. And this RCE association runs through the United Nations University in Tokyo. And I think it's important to point that out, because you will see that when we talk about rights of nature, it's just a more holistic way to approach sustainable development. A lot of people have a problem with the term sustainable development, and I don't blame them, because it means a lot of nothing sometimes. But I want to be very clear about what rights of nature means and how it relates, I think, very holistically to sustainable development. When the term sustainable development was originally coined in 1987, the term meant solely sustaining today for future for future generations. But a lot of times we attributed sustainable development only on one of those anchors, which is the economic anchor. But we know that sustainable development has the anchor of people, planet, and prosperity. Oftentimes, though, in the late 80s and through the 90s, we focused that development solely on economic development. Some of the consequences of that economic development, much of those consequences impacted our environments, our people, our cultures. Many of the things that Lynn talked about really are applicable to the struggles that we face in approaching a more holistic and balanced decision-making approach through sustainable development. So tonight I want to talk a little bit about what does it really mean, rights of nature. It's, as Lynn pointed out, it's a new term. It's a term that really is based in a philosophy called Earth jurisprudence or Earth law. And if you're interested in this, I can point out that Thomas Berry would be someone that you should read. He talks about the great work and that all living beings are interconnected and they have rights, and we all have responsibilities to one another to live in harmony and balance. Some people call it earth jurisprudence, some people call it ecological jurisprudence or earth law. Cormac McCullonan is someone in South Africa who writes on this. Michelle Maloney writes on this, and they often refer to it as earth law. Law that encompasses not just one aspect or a fragmented aspect of people pushing forward for one type of development, but recognizing that ecosystems that we are all nested within an ecosystem. Humans, other living creatures, we're all nested inside one ecosystem together, and we have to live within harmony of that ecosystem. So this is a philosophy that tries to essentially codify or create laws that recognize that ecosystem knowledge that we have. And you may be saying to yourself, well, okay, that's really great, it's interesting, I mean, but does it really exist? In fact, we're finding that it's skyrocketing. I'm also an expert panelist on the United Nations Harmony with Nature program that I'll talk about in a little bit. And there are right now over 180 rights of nature laws in 18 different countries in 5 continents around the world. And of course, your country is one of the most recent ones, Canada. So what exactly does an earth law say? It is about protecting, I think Lynn mentioned that, restoring and stabilizing the functions of our ecosystems, recognizing our human interdependence with our life support systems, our ecosystem. And so that's the definition of earth law. Why is it different? It's different than conventional Western law because conventional Western law was built on the premises that man or woman can dominate nature, that we are separate from nature, that we use nature as an item to further our own human development, and that nature can be thought of as a commodity as opposed to a living support system. Those laws are also based on property, of course we know that, and stocks of resources. That's how we have traditionally defined nature. And economic development is really built on growth and exponential growth and consumption, so that the way an economy grows, it grows through increased consumption. That growth is associated with development. And as such, our laws tend to legalize harms to our ecosystem by giving permits to that. We have all heard of environmental permits. Those permits are just the ability to have a level of harm to an ecosystem in Canada, in the United States, and in many places around the world. And I'll talk a little bit about how earth law can be used in a river situation to rethink that premise. And so earth law or rights of nature laws talk about humans being a part of nature, that we are nested or we are biotic communities. We're interconnected, right? Land knows no borders, water knows no borders, and yet without land and air and water, we have no life for us or for other living creatures. And so it's maintaining this equilibrium and balance. That's the goal of earth law, is an equilibrium and a balance, not a goal of taking out or extracting individual stocks of items, but rather achieving a balance and creating a healthy ecosystem and preventing extreme harms, the precautionary principle to prevent those harms. And so I mentioned this already, but it's the idea, and this has been codified, and I'll talk a little bit about this, that nature and ecosystems have the right to exist, to thrive, and to evolve, and that nature should be able to defend its rights in court just like people can. And so here, it corrects some of the flaws, rights of nature, that we've had in our legal system, so that natural systems don't just have the right to exist, but they can maintain its functioning. It's not changed. It's not cut off. It's not damned, for example. It's not intentionally overused or harmed in some way. And that if it is damaged, it should be restored to its natural evolving cycle. And so the idea is to create, give health to nature. And this, the premise of this, so some people may say, well, wow, this is really so eco-focused. Where are the humans in this? Well, the humans are dependent upon this. So the idea is that it's nature rights, or rights of nature, are human rights. It's our right to have a healthy, thriving, evolving ecosystem, because that's how we maintain our own healthy status as human beings. It's also premised on indigenous rights. In Ecuador, it's called Buen Vivir, or Sumak Kausai. And I should say that I moved to South Carolina from Ecuador, where I worked on these issues for a long time and continue to work on them for now closing in on 30 years, which is hard to believe. But indigenous peoples in Ecuador believe that they are one with the forest, one with the water, that they are sacred beings, and in many cases parts of their family. And so that type of protection is a sacred protection. And so part of rights of nature law is hearkening us back to recognizing the sacred values of our natural world and what they mean to supporting human life as well. So humans are integral to it, but we recognize our balance within that system. So nature is then given a voice, and some of the ways nature is given a voice is in guardianship councils. That's something that I've been working with local people here in South Carolina that I can talk to you about. But guardianship councils are simply very similar to what you know as a provincial council or a municipal council. They are formed to be able to apply these principles of rights of nature. And also nature is given a voice by given legal standing in court, so that in many cases, citizens can go to court in order to give nature a voice and protect nature. In some cases, nature has a political representation. For example, nature can be represented by means of a policy. And a good example of that is Blue Mountain in Australia. Now their Blue Mountain Council recognizes that the underlying principles of all of the policies they have now and moving forward will be represented through giving nature a voice. Would this harm nature? Does this keep nature in balance? It's definitely a different optic or lens through which to create your policies moving forward. And that rights of nature must be considered in decision making. And by the way, I just want to say to anyone who's watching, because I'm on my iPad, we had some problems with my webcam on my computer. I have a testy Mac, and I apologize for that. I can't see the chat board, but Chuck, feel free to interrupt me, or Lynn, or anyone at any time with a question or a comment, or someone. I'm sorry that I can't see the chat myself, but I'm most happy to be interrupted and have a dialogue as I'm talking. So I wanted to put this quote here. It's a great book called Wild Law. It's in various editions, but Cormac Cullinan in South Africa talks about this from an African perspective, one of agricultural tribal communities. He talks about the fundamental and inherent right of beings, not just humans, and that all these beings have already, they possess this right, and they don't actually need to be granted this right. Very similar to the Declaration of Human Rights, that humans have an inherent right to life, to water, to shelter, to security. And he says that's exactly what all living beings have. And when he, something that I find very hopeful, especially recognizing that we're all still in the middle of a global pandemic, that rights of nature is a hopeful message, not a law to punish, but a law to thrive. I mentioned the United Nations Harmony with Nature program, and I welcome everyone to look at its website. It is right now the most comprehensive listing of all of the laws. It's a great way to look at the actual legal documents. You can find, for example, in Quebec, the Magpie River document. And so this was established, as you can see, in 2009 from the United Nations General Assembly, and essentially recognized on April 22nd on Mother Earth Day. I, among many other scholars around the world, form a part of this program to help keep updating laws around rights of nature and earth jurisprudence. I would be remiss to not talk about, and I think my slide is a little off from this sharing, I apologize for that, but essentially what this talks about is sustainable development is balanced decision making, or the triple bottom line: people, planet, and prosperity. And there is the Brundtland Commission's 1987 definition that I cited for you. The current sustainable development model, you can see on the left of the screen, the nature, the people, and the economy, and those overlapping barriers. But what the concept of rights of nature talks about is that really nature is our threshold. Nature is the system in which we have to function because we are dependent upon it for water, for air, etc., for food, our basic needs. And so within that, people's rights should be placed and our economy should be placed within it, so that our economy doesn't outgrow nature, so that we don't push nature to unhealthy, imbalanced situations and capacities. And these are the Sustainable Development Goals, my friends that are with the RCE. We know them well. We try to apply them in a local sense, and there in Saskatchewan you have one, so I know you're familiar with this. If you look on the bottom, the way I like to think of these goals, and I'll show you a more visual slide by a wonderful scholar and attorney in England, Mumta Ito. But if you look at the bottom of this, the Climate Action Goal 13 through 17, it's the natural goals, right? Our natural goals on which everything else is balanced. And through that, we form peace and justice and stronger institutions and collaboration and partnerships. And that's the way I like to think about the Sustainable Development Goals in the context of rights of nature. Many times, and some people may be critical of this, but I'm just conveying to you the perspective of rights of nature. And I should also say that I'm a member of the academic hub of the rights of the Global Alliance of the Rights of Nature. And I talk with many colleagues, including Kelsey Leonard, who's in Canada, First Nations in Canada. And one of the criticisms of the Sustainable Development Goals is that sometimes we'll pick a goal, like we're going to focus on education, but to the isolation of the other goals. And what a rights of nature approach says is there is no health and well-being, there is no education if we don't balance ourselves upon these natural goals. And what does that look like? It looks something like this. Again, this is from Mumta Ito. But it looks like figuring out in your lake region, for example, or in my bay region, what are our carrying capacities for land? What does climate change look for us? What does water quality look for us? What are those boundaries? And then look at the goals, the natural goals that you can see, nature, and then place people on top of that and figure out how people can help support those planetary boundaries and those nature goals. And then finally build the economy so that it supports that system, so that it's not the economy, right, that's here driving nature, but rather it's nature supporting a healthy economy, supporting a healthy people. And that includes culture, in whatever way cultures see their natural world, either sacred or as just simply special places and quality of life. And it's different for all cultures, of course. And so you can't see on the screen, but what I'm trying to say here is, bridging the local to the global. In 2015, the United Nations passed the Sustainable Development Goals. All 193 member nations passed those goals in the hopes that we would work together till 2030 and beyond to fulfill these goals. That's obviously a very large challenge, especially in the face of COVID. But the point is that there is nothing more local than the lakes that Lynn talked about, or the river on which I live that flows out into the bay. And yet absolutely nothing more global than the application of protecting, preserving, restoring, and creating balance in these special ecosystems. And that is really the tie to the Sustainable Development Goals. So on the left, you see the goals, and on the right, you see the rights of nature symbol. And what you can't see on your screen, but is on my screen, I think the sharing screen is a little off, is a local community. So it's that local community perceiving its own special places, wanting to preserve and protect them, and then measuring that and being transparent about it through the goals. And if you're wondering, well, how are these ecosystems so special to us? How do we see it out there in the international environment? The Future We Want is the document that was the form and basis of the 17 United Nations Sustainable Development Goals. And in it, it says that we recognize planet Earth and its ecosystems as our home, and that Mother Earth is a common expression that countries and regions use to recognize the rights of nature in the context of the promotion of sustainable development. And I point this out to say that sustainable development then in the context of rights of nature is not solely pivoting yourself on one of the three stools of people, planet, and prosperity, but rather nesting ourselves in a healthy environment so that we can all move forward in an equitable manner together. And how do we do that? Well, how do we reflect nature's cycles and human needs? First of all, we look at the legal order tends to fragment issues between air and water. And the funniest thing is when you talk to a First Nations person or Indigenous person, and you try and say something like, well, we're just going to talk about rights of rivers. And they say something like, that is just really stupid, because rivers are dependent on people and its biodiversity and its flora and its fauna and the land. And you just can't think about giving a river rights without seeing the rights of all the living beings that interact with that river. And yet, for example, in the United States, we have the Clean Water Act and the Clean Air Act, but we don't have the Clean Ecosystem Act. But science tells us that our ecosystems are mutually interdependent and supportive of themselves and of human life. And so the view of living organisms as sort of being replaced or extracted for economic wealth is actually changed to looking at how economic wealth is actually dependent upon strong living organisms and ecosystems. And that scientists, we know now, we see climate science and biological sciences every day not identifying just discrete parts of the ecosystem, but the fluid, dynamic, and interconnected community of life that's best understood in terms of its cycles, its patterns, its interrelationships, and interdependencies. So, where am I going with this? Where has this really happened? Well, it happened in a place that I call my other home, which is in Ecuador in 2008. Article 71, 72, and 73 actually give nature its own rights. And you may say, why? Why did they do this? At the time, there was a new president, and there were a number of environmental organizations that got together and indigenous organizations that got together, and they wanted to. Ecuador's economy at the time was, and still is, very dependent on extractive oil extraction in the Amazon, which most of my academic work has been based on looking at the impacts of that. And but yet 40 to 60%, depending on the statistics of the country that you look at, of that country is indigenous. And their belief is in sumak kausai, or this concept of integrated harmony with nature and well-being. And so sumak kausai became the platform of sustainable development, a more holistic approach, so that extraction from the Amazon was not considered sustainable development. That same extraction of the Amazon in the early 90s was absolutely sustainable development, many times even in the United Nations, and funded as such. And so the Constitution of Ecuador in 2008 wanted to set an example. It's the first one that codified nature's rights, giving rights to nature in the world, to say that nature has its own right and that anyone, any citizen can defend that right in court. Well, I'm going to be really honest with you. I saw that pass, and for a second I was elated, and then I thought, well, that'll never happen. And we see extraction in the Amazon for oil, and there's all kinds of environmental policies, and yet still there's massive extraction. And I could show you pictures of me throwing rocks on top of just solidified petroleum in pits in the Amazon. And so we thought it'll never happen. And the following year I had a Fulbright in Ecuador, and I went with my family. I have a husband and 2 kids, and I started to discover that at a very, and this is why I asked Lynn about her role as being a mayor, at a very local level, local municipal judges were just simply looking at their constitution and saying, yeah, you've just harmed nature, and it's now a constitutional right, which means it preempts every other right in the country. And suddenly we saw 13 cases in the matter of a couple of years. And now in Ecuador, we're approaching 38, 40 cases that are giving nature its own rights and actually changing policy. In one of the cases, the Piatua River case, which I think the judgment on that was 2019 or 2020. But in that case, there was actually a permit, an environmental permit was given to a municipality for a road to be built, but it was destroying the river. And in fact, it was taken to court that the river was being destroyed, and the judges said it's not enough to have an environmental permit. Sustainable development means giving nature rights. So this is the first time Ecuador saw, just to give you an example of how you would implement at a constitutional level. It was the first time that Ecuador saw that even if there's an environmental permit to create a road, which people need for traffic, we understand that, but yet if it's destroying the ecosystem, it's not legal anymore. There has to be something that's done, and you have to remediate that to restore the river to its natural cycle. So that's just an example. Now, this is Kathy Miarelli. I really like this, and these are stories of rights of nature that they're all, of course, formed on laws. They're based on laws, right? But nobody wants me to read them laws, especially it's 9:35 here and 7:35 there. But the story of Kathy is an interesting one. She was a school nurse, and she started to see a rise in illnesses among the children in her school. And so she, at the same time, was working on her master's degree in nursing. And she started to study the impacts of pollutants and contaminants in the environment on human health. Unfortunately, her husband even got cancer during this time period. Kathy learned about the application of the rights of nature through a Community Environmental Legal Defense Fund, which is a large nonprofit in the United States that works on this issue. And she passed the first ever, before Ecuador's constitution, in 2006, rights of nature law at the township, Tamaqua Township, very local level in Pennsylvania. And that was simply to prevent sludge pits from being built and placed in her community and then seeping into the soil and thus their water system. And she linked that to the impacts on human health, particularly the human health that is the most vulnerable, which is in the youngest and the oldest members of their community. That is a rights of nature law that is still in existence, and Tamaqua Township is a very, it's one I think a lot of people in the United States look to because it's just a small town. And in 2014, following in Pennsylvania as well, on the heels of that, Grant Township was being threatened by an oil and gas company from hydraulic fracturing to place its wastewater in wastewater injection wells in this township. This is a township that has something like 700 people. It's very small. They depend on their Little Mahoning watershed. That's Stacy Long and her mother and another one of the Board of Supervisors. And just to give you an example of how dedicated these people are, Stacy's mom was in the hospital with her father who was dying, and I was interviewing her while she was in the hospital because she was so adamant about getting the story out on this community wanted to protect its watershed and its way of life. It's an agricultural community, and its livestock depends on clean water. And they passed a law for rights of nature, and then subsequently a local constitution, or what we call home rule charter. They were sued multiple times by the oil and gas company, including sued by their Department of Environmental Protection of Pennsylvania, their state. And then finally, the state of Pennsylvania has in its constitution the human right to a healthy environment. And right now, this group of local supervisors, that's what they call their council, is waiting for trial to implement their right to a healthy environment. So they are at the precipice of potentially making some precedent in law in the United States at a very local level, because of course in the United States, and one thing I guess I should immediately point out is since countries like Canada and the United States don't have a rights of nature constitutional article or amendment, we depend very much so on our local communities and local laws for implementation of this. Again, another group of local people trying to protect their ecosystem in 2012 in Highland Township, Pennsylvania. Again, this was about a wastewater injection well. And they did the same trajectory of an ordinance followed up by a home rule charter, and they were opposed by the wastewater injection well and the oil and gas company. They lost that battle, and now there is a wastewater injection well in their area, and they tried to use the rights of nature law, which they did, but their board of supervisors felt so threatened by the multinational corporation because they were telling them they were going to sue them personally that they didn't continue the lawsuit. And that is, let's say, a real testament to the local people who, again, I interviewed and are kind and generous people who are trying to implement this type of legal framework in a system that, as we've talked about, is really built upon extracting resources, not giving resources to our environment. And so that was a real challenge. But talking about water rights, let's talk about the Wanganui River. And this was really land breaking, path breaking, and I think it speaks to a lot of the things that Lynn mentioned about the treaty agreement with the government and local communities and First Nations. The Maori, iwi in New Zealand passed the rights of the Wanganui River, recognizing it as a person, giving it legal personhood. And this was the first of what subsequently India and Colombia did the same. And what's interesting about this is it unlike in Ecuador, that has a constitutional amendment, the way that the Wanganui River was formed, it created a guardianship council. So it created a new way of governing our water systems. And so this also was a way to integrate this system. And I'm going to talk a little bit about, it's composed of one of the Wanganui iwi indigenous representatives and a Crown representative. And the important part when talking with the indigenous peoples of the Wanganui is that they consider the river truly a person, a part of their lives and their families, and that it has spiritual and cultural rights that aren't just simply physical or ecological or scientific to them. It goes way beyond that for them. It's a relative. And so they created this guardianship council, not because they wanted to own the river. That's not what they wanted. They felt like they had a responsibility to work with the river, to protect the river. And so there you can see there's also an advisory group that is created to give support to the Guardianship Council and work in the interests of the river. So not in the interests of the property owners, not in the interest of the Crown, not in the interest of the iwi themselves, but in the interest of the river. It's just a completely different dynamic when making policies then. And again, in New Zealand, another interesting case, the Te Aroha National Park. This actually gave a right to a forest, and in the sense of it being a living, breathing, evolving being, and paying attention to the signs of the forest and communicating it. And again, this created a governance structure with 3 types of actors, a board that speaks for the rights of this forest. It also has an operations team that works in the 4 different valleys. And that operations team is built on bush crews, right, that speak more directly with the forest, that interact with the forest, that know the forest, and believe in its sense of being a living being. And so this operations team, they compile information, they create a holistic picture of the state of the forest, and they use that to make operational decisions about how the Tūhoe, this indigenous group in New Zealand, will manage their land. So something that I've always been fascinated with and learned quite a lot from, and I happen to live on the Waccamaw River in South Carolina in the United States. So I find this fascinating, I think, from a personal perspective as well as a scientific perspective. The cosmos of the river, and the indigenous perspective on rivers as living beings, right? That's what giving personhood to a river really is talking about, and the connection to the people, and this inextricable link between humans and the natural world. And that really has been fostered by the Global Alliance of the Rights of Nature, this movement of indigenous and non-indigenous activists and scholars and organizations to look more deeply about how to apply the concept of earth jurisprudence and rights of nature. And I've already mentioned the UN Harmony with Knowledge Network. Another water way that I'd like to talk to you about this evening is the Rio Atrato in Colombia. And I had the great pleasure and good fortune of sitting with Judge Jorge Ivan Palacio in 2018 at the 10-year celebration of the rights of nature in Ecuador's constitution. And the interesting thing about his story, first of all, he really wanted to tell it. But second of all, he saw the destruction of the Chocó, this very beautiful, highly biodiverse region, and it's Rio, it's river. And upon that river are Colombian indigenous and Afro-Colombian peoples. And so he was the first in Colombia to give rights to the Atrato River, to protect it, to conserve it, to maintain it, and to restore it. And the Chocó this is much different than the other cases. This is talking about 500,000 people. And there you can see fishing, agriculture, artisanal mining is there. But the extreme levels of poverty and the mercury levels at 50 times higher than the World Health Organization acceptable levels. It was impacting child health and illnesses and polluting the river, impacting their food sources, obviously their water and their quality of life in their communities. And what happened, I think, is a story that some of us can really relate to. You follow the chain of command in your local or national governance structure. So you say, hey, there's some illegal mining here, and they're putting pollutants into the water, and it's killing off our fish. So you go to the National Mining Agency. This makes sense. But they go to you and they say, yeah, that's fine, but we have nothing to do with health. And so then, okay, fine, you go to the Defensoria, which is like the ombuds of the public, and you say, look, there's a crisis here in this region. There's illegal mining, there's drug trafficking, there's pollution of the river, and it's creating health and other issues. And they create a working group on the issue for years, and nothing happens. And then the administrative court says in 7 organizations in Cundinamarca, the region, they they go and they say, the administrative court says, oh, the agencies named in the suit don't have the authority really to address this very holistic problem of drug trafficking and mining and health and housing and all these other impacts. And so finally it goes to the Constitutional Court in 2016. And what the judge said was, it was just ridiculous. We don't have governance bodies that actually interact with one another and reflect the complex dynamics of living in harmony with nature and how to protect it. And so he mandated in the decision of the Atrato River that there had to be a guardianship council, that there would be auditors to assess it. And you notice that all the different ministries of the environment and housing and defense and government and the non-governmental organizations that were involved had to coordinate with one another. He included the Ministry of Defense, Police, and Mining and Treasury to eradicate illegal mining. And he also talked about agriculture, housing, and the interior to recuperate their farming and food sources. And he mandated toxicology and epidemiology studies on the area. This seems like very logical, but in fact, a Supreme Court judge or a Constitutional Court judge had to mandate this ruling. And so now, today, there are 14 community members in the Choco, and there are guardians. They represent the different regions and organizations. They're working on decontamination, eradicating illicit mining, food security, etc. And that's what a guardianship council, instead of focusing on giving permits for mining, they're focusing on how do they protect the health of the river, focusing on the river. And so there, what's interesting about this is, in his what is the justification? He cites the United Nations Sustainable Development Goals, and that how will we ever implement these goals if we don't change the very basis on which we are all living, which is our systems of justice and a more ecocentric view. I'll also say what's interesting about this is he calls it biocultural rights. The way the judge crafted this law, and it was 200 of the most interesting legal pages I've read. It was beautifully written, and let me just tell you, it's not easy reading 200 pages of legal review, but he talked about the fact that there are biological biodiversity rights and there are cultural rights, and people's cultures are enmeshed in their biology. In other words, in the biodiversity of the area, that their culture of the Afro-Colombians was absolutely inextricably linked to that river. And that it had to then create not just biological or nature rights, not just people rights, but biocultural rights. I think that speaks a lot to the rights of lakes in your area and First Nations. I know that we're getting to 10 minutes to 8 your time, and so I'll be quick on this to wrap up so that we have time for a little conversation. But Cajas National Park is a park filled with beautiful lakes. Very much beautiful lakes like Saskatchewan. And those beautiful lakes and that watershed feed a UNESCO World Heritage Site, a place I love dearly, Cuenca, Ecuador. And what happened was there was mining that was being proposed as an economic development for the country. And Cuenca saw that mining as a threat to that beautiful Cajas National Park, but also to their water supply. And they wanted to hold a referendum for citizens to say that they have the right to oppose mining, to protect their water. They consider themselves water defenders. In fact, Yacu Pérez Huartambel, who is now the governor of this province, Yacu means water in Quechua, in Ecuador. He changed his name to water to say that we are water. We have to protect the water. Anyway, long story short, originally it was denied through the Constitutional Court in Ecuador, and finally in 2021 February, there was a national referendum, and over 80% of the citizens of the city of Cuenca voted to guarantee the rights of water and to eradicate mining. And so that is guaranteeing the participation of communities also, and the impact on their environments. A new one that's forming is on a creek in Colorado, in Boulder, Colorado, and this is just starting right now. They're just developing it, so it's a good place maybe to think about in the Lakes region, but they're thinking of a guardianship body that will solely defend the rights of the creek and the watershed, and receive information and complaints from the public and look into them, take recommendations and compile best practices and release reports on the health of their watershed, and then integrate that with their local municipality. So they're also looking at in-stream water rights on behalf of the creek, so that the creek would actually have its own rights of in-stream water. I'm going to skip that and talk just briefly about, I'm going to just keep going through this. There's many other examples. One, I will say, the Chippewa have passed on the rights of Manuman, which is their rice, which is sacred to them, and their rice is developed in the wetland ecosystems of their area. So protecting those wetlands is protecting their rice. So they gave an actual right to the rice to actually be able to grow, exist, and thrive. There are many pathways to passing rights of nature. There's local ordinances and home rule charters. There are proactive ways, like the city of Santa Monica, and passing an ordinance that has a task force that looks at rights of nature and its applications and implementation, including it has subsequent secondary ordinances that were passed, for example, on protecting the health of groundwater. The Ho-Chunk passed, Indigenous First Nation passed a constitutional amendment. The Ponca in Oklahoma passed a statute. Recently in Florida, just last year, there was a ballot initiative. And of course, the Magpie River in Quebec. And here, the Magpie, what I think is fascinating is it's a dual passage of river rights between the Inuit Council and the municipal council. So it gives the river rights to flow, to maintain its biodiversity, and to take legal action if something happens to it. And it created, it's represented by a guardianship council with members from both the First Nation and the municipality, and it protects the rights and interests of the river. And that it absolutely notes the river's biodiversity and that link to the Indigenous community, but also the importance of that river to the economic development and tourism of that area, which I think is also an important point. And so lastly, I'll just say that what are the implications for Saskatchewan when I look at this? I saw that University of Regina professor who will be speaking in this series did important work on the algae blooms on the lakes and the toxicity to humans. The study notes global warming, urban growth, spring runoff, et cetera, fertilizers. These are things that we can all relate to. And it talks about the impacts on the First Nations and the municipalities and the Qu'Appelle River that was cited earlier by Lynn. And I think Saskatchewan is really interestingly placed to pass an ordinance, a recognition, a policy on rights of nature. And I'll just end with, the world has lost 70% of its natural wetlands over the last century. So no kidding, and kudos to Lynn and all of your colleagues, Chuck, and thank you so much everyone for organizing this, for protecting what we have left. And thinking deeply about this. And with that, I'll end. Thanks so much.
Thanks, Pam. That was excellent. I'm not seeing an awful lot of questions in the chat box. So what I'm going to do is I will unmute all the attendees. So if anyone has a question or would like to chat a little bit about Pamela's presentation or questions you might have, by all means, do so. You should all be unmuted right now.
Can you hear me if I ask a question?
Oh, hey, Roger. I sure can.
Okay, good, very good. I wondered if there is any difference in terms of the kinds of law, right? So we're under British kind of common law, here in most of Canada except Quebec. Are there any strategies that you would use from what you've seen in terms of that way, that British way of thinking about things? And then the other thing I wonder too is in Saskatchewan, the municipalities derive their authority from the provinces. And so I could see if the province wasn't interested in a rights of nature approach, they might just withdraw authorities from municipalities that tried to assert that. So if there's any strategic ideas where municipalities and RMs have derivative powers?
Yeah, thanks, Roger, for that great question. So the Crown approach to common law is very similar in the case of New Zealand. And what the Maori did is they spoke the language. They didn't speak their language. They were not interested in actually speaking the language of the Crown. What they were interested in is, and this is what Casey Camp Hornick of the Ponca also says, First Nations aren't interested in speaking someone else's language. They want to speak their own. But the way to do that is learn the lingo. So they learn the lingo of the Crown. And the way the Crown, they used a strategy with the Crown, and the Crown understood personhood. That personhood did not give ownership. To make the Wanganui River a person didn't purvey ownership to any one party. And so it was fine to then sort of cast personhood on the river so that then they would protect the river like a person. It was just a vehicle to be able to communicate and convey the deep feelings that they had toward the river. So that's a really good example. And your other example of the municipalities deriving from the provinces, their authority, same thing. That was my timer to shut myself up. The same thing in the United States too. And what I can say is the Blue Mountain case in Australia, I think, is a really interesting one. First of all, municipalities can pass pretty easily resolutions, which are just sort of recognitions of things. You can recognize, it's just a way of saying we philosophically believe this. But you can also have local municipalities create policies that say that we will enact these policies based on these principles. And they can be the principles that we just discussed tonight. And those are strategies to sort of, quote unquote, get around larger authority and yet start localizing. And the last thing I'll say is what my co-author Craig and I have found, and the book is going to be open access, by the way. So when it's out, I will send the link to all of you so that you can all freely look at it. But what we have found is the more local, the better. Because the way we relate with nature is really very local. It has global implications, but it's very local. Thanks.
Great, thank you.
Orly, I see you've got your hand up. Did you have a question?
I do. Can you hear me, Chuck?
Yep.
Okay, great. So nice to getting back to what Roger was saying is basically what you're saying is that local governments could embed into their bylaws their desire to make this shift.
And then the next one comes.
And that's probably a good way to start.
Yes, absolutely. Orly, first of all, thanks so much for always being my mode of communication through this process and for inviting me and organizing this. It's really lovely to hear your voice. And yes, local governments actually can be a really positive starting point for this because local governments are very in tune with their citizens, with how they relate to their natural ecosystems and the things that they see that are threats to their natural ecosystems. They see them, whereas national governments, they're not there, they're not seeing it. So one way to start is by embedding these principles just into, I know Lynn mentioned you're one of the panelists is zoning. And zoning is a great way to start. You can start embedding principles of protecting nature in zoning ordinances. You can start embedding them in economic development policies. You can start embedding them in public works policies on how to build roads that don't interfere with lakes or their ecosystems. And those are really simple ways. It doesn't, I mean, wouldn't we all, or at least me, when you're in Ecuador and there's a constitutional article, it's like it makes a big statement. But when you're lacking that, a good way to start that we've found, a very successful way, is at a very local level.
That's really exciting.
It is, and it's exciting. And as I said, you know, we're in the middle of a global pandemic. We're hoping maybe we're not in the middle, but people have really suffered, and I think this is a very hopeful message.
Yeah, and I think the other thing, and I won't keep too much of your time, but I think the other thing that's really hopeful about this is rather than starting to look at, hey, we need a new road, or hey, we need a new something or whatever, you take a holistic approach to it and say, okay, what is the impact of that to the water? What are we, like, rather than just developing without thinking of what the impact is downstream. I think it's hopeful, and I think it has to be a holistic approach. It can't just be this tunnel vision where we need a road. We have to put some thought and some dedication into how we develop.
Yeah, well said. And I will just say that in the case of the Piatua River, where they were developing the road so people could more quickly get through this area, and they were damaging the river, what the argument was, well, it's going to cost us more to remediate the damage to the river in the end. So if you're thinking money, think that this is going to save you money in the end.
We've got another question here, Pamela. Can you elaborate on how guardianship councils are formed?
Sure. So there are different models of them, and I gave you the model that was mandated by the Constitutional Court in Colombia, where they had representation of the different organizations and regions. That's one model. Another model is in the Boulder Creek model. It's a far more local level, and that has representation of diverse members of the community because of their cultural and other quality of life issues to the creek. So First Nations, African Americans, there's a wide array of representation on that council for that watershed. That hasn't passed yet, by the way. Another, though, interesting case is the Ganga River in India. And when they created the Guardianship Council, what the judge said is, well, if you're guardians, you're responsible for it, and there's a potential in our law that then you can be sued for any damage to the river. The local municipalities could have been sued, and so suddenly they said, whoa, they put a stay on the law. They said, we need to analyze this because we don't want to be personally or the municipality responsible. And so that's the case of the Ganga River in India. But in terms of guardianship councils, they're very local. So it would depend on the representation, the river itself. Many times scientists for the quality of the water are involved in that as either ex officio or as members of it, municipal members, First Nation members. So it can be a wide variety. And you can create a guardianship council as an ad hoc committee in a municipality or in a province. It doesn't have to be actually, so I know I've been calling these laws, but actually it can be created without creating a law, and the council can simply be an advisory body to the municipality to start. And then the findings of the guardianship council could actually start informing the laws that the council passes. So that's another way, another strategy.
Thanks, Pamela. Ron, I see you had your hand up. Did you have a question for Pamela?
Other than to say, I've been waiting for something like this for decades, and I greatly appreciate the information, and I'm looking forward to sharing it with other people who have like minds.
Thank you. Lovely to hear your voice.
Jim Range, did you have a question for Pamela?
Yes, I do. I'm on the Turtle Lake watershed, and we are in an unusual situation because we have 5 municipal, or no, actually 7 governing bodies that control the lake in one way or another. The federal government, the Saskatchewan provincial government, we have a First Nation, and then we have 4 local municipalities, resort villages or rural municipalities. The problem that we have is that there's no communication between any of them. Now, what I found very interesting here was that the First Nations, the treaties, are recognized internationally by the international courts and also by the Canadian courts. And so that might be providing a venue. I'm wondering whether that is something that you would suggest we try to use, or it gives us a leg up to get ourselves organized. The way it is right now, there is no real control and no communication amongst those bodies.
Yeah, that's really interesting. So the United Nations Declaration for the Rights of Indigenous Peoples, UNDRIP, that also has been cited in a number of these cases, so that you know. And the Declaration of the Rights of Indigenous Peoples recognizes the rights of Indigenous peoples to have control over their ancestral lands, as well as to have a voice in those processes. Also, the International Labor Organization Law 169, which provides rights to information and to Indigenous peoples and prior informed consent. That's another law that's been cited in a number of these cases. So yes, I would suggest international law is one thing to cite. But I will say that what came to my mind when you mentioned that is the Rio Atrato in Colombia, because that was 500,000 people with a multitude. It's a very long river with a multitude of organizations. And it took them a number of years, by the way. They started this, as you saw, in 2009. The judgment wasn't until 2016 in the Constitutional Court. But they started coordinating with one another and jointly brought this case to court, ultimately to the Constitutional Court. And so what I would say is looking at the international level to highlight the rights of First Nations to their ecosystems as one vehicle to start mobilizing, and that at the same time start mobilizing some type of ad hoc organization that starts communicating solely on the lake. And when you make it that just your focus, solely on the health of the lake, I think it sort of washes away a lot of the other issues, and it provides a focal point for people to work on. But certainly elevating your status as First Nation internationally, absolutely.
Thanks, Pam. I see Ralph has his hand up. Ralph, did you have a question? I guess not. So I guess there's no further questions unless anybody else wants to put their hand up. I think we've reached the end of our discussion. And with that, I will turn it back over to Lynn.
Pamela, much movement towards caring for lakes and rivers. You know, in Saskatchewan, we have a water council that formed spontaneously about a year ago. I'm not sure if I know of, in contact with them, their main concern is that they fear for different water groups, different water locations in Saskatchewan. Canada has a brand new water group. And at their first release about a month ago, they stated in their release that it is a myth to think that Canada is a home for clean, pristine, sparkling waterways that we once, a couple of generations ago, boasted about. That's not true. And this is a quote from that brand new Canada Water Council: "Our waters across our country are under threat." And as I look at the 40, 50 lakes that the groups in parks are located on, I think they can only start one lake at a time, and that it's not a matter of getting bigger, it's a matter of getting smaller. We love this lake. And so there might be 2 resort villages and 1 organized hamlet and two RMs, but all together, there's no reason why we can't come together and say, we love this lake and we won't let things happen to him or her. And that personhood of it, that's the vision you've given me, Pamela, and thank you so much.
Well, thanks again, Lynn, and thanks, Pamela, for the excellent presentation. So that concludes our webinar for tonight. Don't forget, every Wednesday for the following next 4 weeks will be Lake Water Wednesdays. So please visit the park's website and check out the other webinars. Next week we have, as I mentioned, Dr. Peter Levitt talking about water quality. Very timely discussion and ties in very well with your talk, Pamela. So thank you once again and enjoy the rest of your evening, folks.